Good morning. Good morning. Good morning. Good morning. How's everyone doing today? I hope you guys are doing amazingly well because I am doing great and I'm excited to be on this topic with you guys. So, join me. Let me know that you're here when you join me. Say hello. And of course, at the end of my presentation, I will answer a few questions, okay? So I'm here on Instagram, I'm on TikTok, I'm on YouTube, I'm on Facebook. So, and that's the reason why I'm not looking straight at anybody because I have three different screens, okay? So good morning, everyone. How are you? Good morning. I'm going to wait for some people to join so that we can get started. I have a really, really great topic for you guys. You guys know that, as I always say, knowledge is power. Good morning from Atlanta. How are you? Knowledge is power. So the information I'm giving you is to empower you so that it helps you get your immigration process going better. All right. So even if this topic does not concern your immigrant issues, make sure you forward it just because there's somebody out there that it might be useful to. Okay. Good morning, Naxi. How are you? Good morning, King Prince on TikTok. How are you guys? St. Louis. Yeah. Hello, hello, hello. So for those who do not know me or people who are joining my live for the first time, let me introduce myself. My name is Attorney Odunlami. I'm an immigration lawyer. I'm also an immigrant, and my passion and my purpose always is to help my fellow immigrants get legal status so that they can live in the United States without fear of deportation, without fear of family separation. And to help you guys do this, I come on live once a week. I try and I talk about a topic that will give you some information that will, of course, I hope help you make good decisions in your immigration matter. And of course, if you need our assistance, we're here to assist you. We've assisted thousands of immigrants get legal status in very complex immigration matters. Our number is 973-993-1900. Remember that there are people who are trying to scam you. So make sure you're talking to the right person. Be very suspicious of DMs. Call our number 973-993-1900, or you can self-schedule by going to our website www.odunlamilaw.com. So let's get into it. So the topic I want to talk about is what happens when the love gets sour. All right. And I want to talk about this with specificity to an immigration visa type. That's the K visa. So the K visa, aka the fiance visa, 90-day fiance. You guys, for those who have watched that, I have never watched 90-day fiance because I don't watch TV, but that's what has made it popular. Good morning, Michael Tete. That's what's made it popular. But what people do not know is that there are consequences, that there are rules that you must abide by when you come into the United States on a fiance visa, right? So the purpose of the fiance visa, which is to bring the intended immigrant into the United States to get married to the U.S. citizen. As you guys know, only U.S. citizens can file a fiancé visa. So when you come into the United States, you're required to marry the U.S. citizen within 90 days. And if you don't get married to the U.S. citizen within 90 days, you are out of status. Now, it gets even worse. There are certain situations that happen where the intended immigrant does not marry the U.S. citizen, and it has very dire consequences. And that's what I want to talk to you guys about, because you need to know this so that when you come into the United States on a K-1 visa, you know exactly what you need to know, and you know the consequences. So this is what typically happens. So let's say Paul is a U.S. citizen and Rita is an intended immigrant, right? They've been dating for a year and a half, maybe 2 years, because it typically takes about a year and a half for the K visa to go through, right? And then it's approved. A K visa is a non-immigrant visa. It's approved, and Rita comes into the United States on a K visa. So when Rita comes into the United States, she meets Paul. I guess in his, in his natural environment, and realizes that he's not who she thought he was, and that she doesn't want to be with him, she doesn't want to marry him, and she doesn't get married to him because she realizes that this is not the right person for her. So 90 days goes by, she doesn't marry him, she's out of status. And then maybe a year later, maybe 2 years later, 5 years later, it doesn't even matter, she meets another US citizen and she gets married. And that US citizen files a petition for her, right? And she thinks everything is going to go great now because, now she has a US citizen who's filing a petition for her. Well, let me tell you this. That petition by the US citizen for Rita is going to be denied. It doesn't matter what the reason is. It will be denied. And the reason it's going to be denied is because the K-1 visa has restrictions. Only the person who brought you here on a K visa can file to adjust your status. Yes, I'm going to say it again. Only the person who filed the K-1 visa that brought you into the United States can adjust only that person's petition can adjust your status. So that's typically what happens. It's denied. And I have, people who've come for consultations, they've been here for 20 years. They're married to a US citizen. They have US citizen children, but they cannot get a green card. They're out of status. They have no status. They cannot get a green card because they came on a K-1 visa. They didn't marry the person who brought them on a K-1 visa, and they cannot adjust their status on another US citizen's petition. So now let's twist this fact pattern a little and see what the person's options are, right? Well, first of all, if Rita is now married to somebody else, her option is to file a waiver for unlawful presence because she has been out of status since 90 days when she didn't marry the fiance that brought her in here. So she's now out of status and she's been here undocumented. And so therefore, she has to apply for a waiver to forgive her unlawful presence. And when she applies for the waiver, she has to depart. If that waiver is approved, it's a 601A waiver. If that waiver is approved, she has to depart the United States and come back through consular processing. That's one way, right? So let's talk about another scenario which could help Rita not leave the United States. So let's say Rita comes into the United States on Paul's K-1 petition, and they get married within 90 days. So of course, when she gets married within 90 days, the next thing to do is to file the adjustment of status and, file to get her green card, right? But then Paul is abusive. And not only is he abusive, maybe he even goes and withdraws the petition just as part of the abuse, He's being emotionally abusive, maybe even physically abusive, right? And he withdraws the petition, right? And so Rita can't file the adjustment of status because the petitioner, the US citizen, has said, I'm not doing this anymore for you. What are Rita's options? Well, she can file for VAWA, Violence Against Women's Act. She can file for VAWA, she can self-petition and get a green card on her own. But the difference between the first case scenario that we talked about and the second case scenario is that she actually was married to the US citizen. So as the spouse of a US citizen who is in a bona fide marriage and has suffered abuse, she can file to adjust her status under the Violence Against Women's Act. And I want to add here that the Violence Against Women's Act does not apply only to women, it also applies to men. So let's be clear about that. It applies to men, applies to children, applies to parents of adult US citizens, okay? So it's important for you guys to know that you may have, if you came in here and you got married to your US citizen petitioner, you have options through VAWA. And if you didn't marry the US citizen petitioner, you may also have options under other humanitarian processes, right? U visa, T visa, So, but what you need to know is If you come here on a fiancé visa, there are restrictions on your ability to adjust your status. Marrying another person will get you denied. And if your if your case is denied, there's always the chance that you may put in deportation proceedings. So for those people who go hire somebody or maybe file the petition themselves, I think it's really more frustrating when you hire somebody who doesn't realize that you cannot adjust your status on the petition of another person other than the person who filed your K1 petition. And then they get denied, and that person is placed in removal at deportation proceedings. It's very frustrating. So it's important for you guys to know that you cannot adjust your status on the petition of somebody else that you marry if that person is not the person that filed your K1 petition. So that is the little tea for this morning. So I'm going to take a couple of questions, and then, I'll be back next week, okay? So let's see. John Aforve says, good morning. How are you? I'm doing great. Thank you. John says, does it apply for green card holder? Well, a green card holder cannot apply for a K visa for anyone. Only U.S. citizens can, right? There's a requirement that only a U.S. citizen can apply for a fiancé visa. There's a requirement that you have seen that person within 2 years of the application, okay? So Glenn Aladdin says, good morning, the best lawyer. Good morning, Glenn. How are you? He says he received this prima facie renewal letter. You're welcome. He says, thank you very much to you and your wonderful team for all the help from the day one with your great team. You're welcome, Glenn. Happy to help. Benedicta, how are you? How's everything going? So let's see if we can answer a few questions on Instagram, on TikTok. So put your questions in, okay? Let's get started. So while I'm looking for the questions, let me encourage you guys to go on my website and sign up for our newsletter. We send out good information from a newsletter. So that might be helpful to you. So I have a question here. Somebody says, if you're what's the question now? Hang on, let's see. As an Afghan student who has an F1 visa, can you apply for asylum? Of course, you can apply for asylum as long as you fulfill the requirements of asylum, which is you have to prove persecution, you have to have a fear of persecution, you have to apply within the requisite time, okay? You certainly can apply for asylum. Yes, you can. Let's see. I'm looking for questions. So Dwayne White says, that's true. I guess, Dwayne, you came in here on a fiancé visa, right? Now somebody says, I've done my biometrics a few weeks ago, but I'm short of cash and I need to go home. What can I do? So crypto, I don't have enough information to be able to answer your question. But I want you to know that depending on what you applied for, you want to make sure that you have the permission to leave the country, because if you are out of status and you don't have advanced parole, you're not going to be able to come back in. If you're on F1 visa, F1 allows you to go back go in and out. So it really depends on what petition you did your biometrics for. So I can't answer that question without having more information. So let's go on TikTok and answer a couple questions on TikTok. I'll be back. Somebody says, hi, ma'am, how are you? I'm doing great. Okay. So someone says, how long does it usually take to get a response from an I-290B? So, it really varies. Sometimes you get a response really quickly. Sometimes it'll take a year. Sometimes it takes 2 years. So what I'm going to encourage you to do is go to the case processing website and see how long it's taken. It really varies. Okay. All right. So someone says, can I get travel documents? It depends on which petition you applied for. Somebody said, I want to move to the United States through athletics. I don't know much about that. Unfortunately, Kende, sorry, I can't help you with that. I don't do that area of immigration law. So Lizzie says, how long does it take when you file your marriage-based green card? Again, it varies. It varies based on where you filed from. So go to the case processing website and punch in your information, punch in your service location, and it should give you a better idea of how long it's going to take. But on an average, I typically tell my clients to expect that it will take about a year. That's the average, okay? So Ship Shop says, what is the purpose of applying for a religious visa? So the religious visa is really a visa that allows the religious entities that are properly designated, right, to employ people to come in to work, right? They're working in their churches. If you could be working as a pastor, or, a choir person, whatever it is that the church needs, right? And there are strict requirements as to people who can file the R1 visa. You have to have been a member of that church for at least 2 years, and of course, the church has to have to be in the United States, right? And you can apply for an R1 from within the United States if you're here, but you have to be in legal status. And if you can also apply for it from abroad, okay? So a church has to petition for you. So you have to find a properly designated religious organization that's willing to sponsor you, okay? So somebody on TikTok says, Kevin Reed says, can my citizen mother and brother sponsor me after I was deported over 20 years ago? So Kevin, it depends on why you were deported, right? It depends on why you were deported. And of course, if you have an inadmissibility, we have to figure out whether it's waivable. So if it's waivable, your citizen mother and brothers can sponsor you. Of course, it's going to take a really long time because I'm assuming you're over the age of 21. And so for a sibling, that's like clearly 10, 15 years, maybe even 20, depending on what country you're from. If it's a parent and you are married, it's going to take a long time. If you're single, it will still take a long time, but not as long. So it all depends, okay? So if you want to know for real if you can come back to the United States after deportation, you really want to talk to an immigration lawyer, okay? All right. So Benedicta says, what about someone with a VAWA case since 2018? No response from USCIS after an RFU was responded to. That's taking a long time because 2018 is what? 6 years. I don't know why it's taking that long. I think you might want to reach out to an attorney to help you place an inquiry because VAWA cases are taking 2.5 to 3.5 years, maybe 4 years, but 6 years is really a long time. So I think that's way too long. All right. So let me see if I can answer a couple questions from YouTube and Facebook. So let's see. What may be the reason for a delay in an I-130 for almost 2 years? The petitioner is a U.S. citizen. They even have 2 kids. See, Benedicta, it really depends. Sometimes U.S. CIS is doing a fraud investigation. Maybe I found that a lot of times when a case is taking a long time, it's because there's something that they're looking into, right? I mean, sometimes it could be that because they're overwhelmed, because there's a lot of there's a backlog. But sometimes they may be looking at certain things. For instance, the prior divorce decree, was it properly done? Is that marriage a valid marriage in the sense of the petitioners and the petitioner and the beneficiary having properly terminated prior marriages? So that could be it. Or maybe one of them has an immigration history that is a bit sticky. That could be it as well. So just because you have 2 kids and you're in a bona fide relationship does not mean that your relationship is not under scrutiny if you have some kind of misrepresentation or fraud in your past or some kind of immigration history. But sometimes it's just that they're backed up. So backlog is a common problem with immigration cases. So there are things that you can do. First of all, you can reach out to your congressman, do a congressional inquiry. You can reach out to USCIS, call them, find out what's going on. And if all else fails, you can file a writ of mandamus, and they will answer you because they have to explain why it's taking that long. My office does a lot of writ. We file a lot of writ against the government. There's no consequence, there's no retaliation, and we've been very successful with getting our clients the answers they deserve. So it may not be anything more than just a backlog, or it may be. So maybe talk to a lawyer and let them screen your case properly to figure out what could be the issue. But regardless, I think it's important to get an answer, right? So John says, is there another way green card can bring a fiancé other than a marriage certificate? A green card holder can file for their children, unmarried children, under 21, over 21, and the spouse. So yeah, those are the ways a green card holder can file for their family member. But a green card holder cannot file for a fiancé. Okay. So you and me says, good morning. My father-in-law applied for his son in Haiti, then he passed away. Can he get a change to come to us? You and me, I'm really sorry for the death of your father-in-law. So it depends on whether the I-130 was approved before your father-in-law passed away. So if the I-130 was approved before your father-in-law passed away, his son may be able to come to the United States through something called a humanitarian reinstatement. Okay, so you want to talk to a lawyer about that. Give us a call, 973-993-1900. All right. So Naxi says, how long does it take to get a work authorization with a T visa? So Naxi, there was a new law that allowed us to file for a T visa and a work permit contemporaneous at the same time. And that went into effect August. And so this is the first time that we're filing a T visa and a work permit at the same time because of this new great law that allowed us to do that. Because in the past, you had to be on TV. You had to have been approved for your T visa, then you would apply for a work permit. So I cannot tell you how long it's taking right now because all our new petitions just went out in August. So we're kind of keeping an eye on it. But like I always say, if you're looking at how long things will take, go to the case processing website to get an idea of what USCIS is going to say that the processing time should be. All right. All right. So let's go and look for other questions on Instagram. So Chris Son, Onyedinachi says, hello, ma'am. I had a brief meeting with you, came away forward and been following up with your colleague. I have not heard back. So Chris, call the office if you had a meeting with me or my colleague, and I don't know what it's about, so I can't answer that. But the best thing to do is to call the office, 973-993-1900, okay? All right. Let's see. So Crypto says, I've done my biometrics a few weeks ago, about 6 weeks, expecting my green card. I came here with a K1 visa. Can I travel outside the United States? Only with an advanced parole document. Only with an advanced parole document. Okay? All right, Crypto. Or with a green card if you finally get it. Okay, I think I already answered your question. I am Benedicta. So can a green card holder whose partner has refused to file taxes together still get his citizenship? When you have a green card, right, you be naturalizing now depends on you, right? But USCIS is going to want you to have filed your taxes. That's part of the requirement for naturalization. So if your spouse is not filing their taxes, maybe you should be talking to your accountant to see how you can file your taxes, because you got to file your taxes, okay? Otherwise, you're not going to naturalize. So House of 1987 says, if I get divorced in a 2-year green card, can I leave the country and come back? I don't have enough information to answer that question. If you have a 2-year green card, that allows you to travel, right? As long as your green card is valid, right? If you have a 2-year green card and you've applied to remove the conditions and you have the 4-year extension, you can travel because your green card is still valid pending the adjudication of your case. All right. So Timsy says, "Good morning. How are you doing? When your fiance, who's a U.S. citizen, comes to your country and gets married to you, but later returns to the country, what visa will you have to apply to come to the U.S.?" Okay, so Timsy, that's a really good question. So you were engaged to a U.S. citizen. They came to your country. They got married to you. So you're now a spouse of a U.S. citizen. So your U.S. citizen spouse needs to apply for an immigrant visa for you, because a K1 is actually a non-immigrant visa. But once you get to a U.S. once you get married to a U.S. citizen, you're looking at filing an I-130, I-130A. That's an immigrant visa. Putting it in. Once the I-130 is approved, then you go through the National Visa Center and conclude the case through consular processing. They will call you for an interview. If you get approved, then you come back into the United States with a green card approval, which you will get your green card when you come to the U.S. Okay. All right. All right. I'm trying to look at questions here. Let's see. Okay, let me go to TikTok. I'm just going to ask a few more questions and then I got to go. So Margaret says, my husband filed for son for 13 years, no response. So, well, how old is your son? I think I'm going to need more information on that, because it may be that the priority date has not been reached. And when you say no response, what do you mean by no response? The I-130 hasn't been approved, because it's kind of odd if at least the I-130 hasn't been approved in 13 years. So I think you need to talk to a lawyer, okay? All right, guys. I'm going to head out now because it's already 11:30 and I have a meeting, but it was a pleasure talking to you guys. So remember to feel free to share this to anybody that you know, because you never know who might benefit from this information. It's really important for people who are here on a K visa to know what the restrictions are on their visa type and to know what their options are if the relationship doesn't work out. Okay? Take care, everyone. Have a great week. Bye-bye.